My name is Inna Lipkin. I'm an attorney and I practice immigration and nationality law. I've been practicing law for the last 16 years, helping immigrants find legal status in the United States. On November 20th, 2014, President Obama issued an executive order allowing for immigrants to receive lawful status and a work permit. Of course, they've got to qualify. First, you must prove that you've been in the United States since January the 1st, 2010. It's very important to gather as much information and documentation to establish that you've been here for the last 5 years. That kind of proof would include your tax returns, W-2s, pay stubs, receipts with your name on it, lease agreements, and other documents. The second thing that you should prove is that at the time the law was enacted, November 20th, 2014, you were the parent of either a legal permanent resident or a United States citizen. Third, you have to show good moral character, meaning that you have not been convicted of a certain disqualifying crime and that you wouldn't be a risk or danger to the community. We expect that sometime in May of 2015, United States Citizenship and Immigration Services will issue guidelines as to what forms need to be filed to get a work permit and how to begin the process. There's another group of people who will benefit from the executive order. Those are the individuals who otherwise did not qualify for the Deferred Action for Childhood Arrival program, also referred to as DACA. Now, if you can prove that you were present in the United States on January 1st, 2010, that you were under the age of 16 at that time, and that you have either completed high school and received a diploma or are currently in the process of receiving one, then you can also apply for DACA relief and get a work permit. That is, even if you are over the age of 31. The previous law did not permit people who were over the age of 31 to apply. Of course, there will be a criminal background check and an applicant has to qualify. I think it's very important for people to go to immigration attorneys that are licensed with their respective states and not go to a notario or a consultant to handle such important paperwork that could be life-changing. You don't want to risk someone making a mistake or defrauding you. For example, right now, you cannot apply for any benefits because the government has not issued the forms yet that are required to be filled out. Don't be fooled by someone who wants to take your money and promises you legal status. Beware of anyone who promises you legal status now before the regulations even come out. The best way to check and be sure that you're dealing with a licensed professional is to ask to see their diploma, or you could look them up online. For example, if the attorney tells you that they're licensed in the state of California, you could go on to the California Bar website, www.calbar.org, and find out, is that attorney licensed? Do they have any disciplinary actions against them? You want to go with someone who is experienced and trustworthy to help you get legal status. Asylum is a kind of immigration relief that lets you remain in the United States if you can prove that you were persecuted in your native country, and in some circumstances that you fear you're going to be persecuted in your native country, and you don't want to go back, you don't want to be hurt by anyone. In this instance, you file an application for political asylum. Filing for a political asylum definitely requires the help of an immigration attorney who's experienced in particularly filing for that kind of relief. There's a lot of documents you will want to gather to prove your claim, and you want to be prepared. Make sure that you discuss everything that happened to you and everything that you want the court or the asylum office to know about your case. If you win political asylum, 1 year later, you are eligible to apply for a green card. This was really a great benefit now to many immigrants. I think this is a really great program because it expands the number of people who can qualify. Previously, if you were married to a United States citizen and qualified in all other ways, you could begin consular processing here in the United States by filing for an I-601A waiver. Now you can qualify for the program if you have a legal permanent resident child or a United States citizen child or a United States citizen parent. Previously, you couldn't file unless your spouse was a United States citizen. I'm Inna Lipkin, and if you have immigration questions, I'm here to help you.